committee, and the very first thing on the agenda here is request for bill introduction. Anybody have a bill introduction? Representative Chair Carpenter. No stranger to this committee.
Thank you, Mr. Chairman. Committee, good to see all of you again, a lot of you again anyway, that were here for a couple of years. I have RS 0896. This bill pertains to non-resident waterfowl hunting this season, and they can hunt Sundays, Mondays, and Tuesdays. And how this bill shouldn't even really be in the legislative process, but this bill and Wildlife and Parks got caught up in the bill that we passed last year, 2648, which required a economic impact study for anything over $200,000 worth of economic impact and $1 million over 5 years. And I get that. I supported that bill, and I still support that bill. But on wildlife issues, it's a little different. They had been working this bill or this language for 2 years, and just before they were ready to promulgate that bill, the bill went into effect, 2648, which triggered this economic impact. And I challenge anyone on this committee, and I'm getting off into the weeds here, to do an economic impact study about non-resident waterfowl impact when it comes to dollars and cents. You'd have to contact restaurants, you would have to contact hotels. I suppose you would actually, gas would be involved in that process because they drag boats up there. So it's just really a can of worms that it would take a university study to do this. And so in lieu of that, which I think is part of the reasoning for the bill, is that it comes under legislative scrutiny. And so in lieu of that, and with that, I'll get off my soapbox and stand for questions.
Committee, are there any questions? Representative Corbett.
Several things. We shouldn't have to be doing wildlife and parks work, and it seems like it gets worse and worse every year.
I do not disagree with this, Representative. As you well know, I have fought diligently to keep the legislature out of wildlife issues. We're not experts on the subject, even though when we're elected to the legislature, we think we know everything about everything, but that's not always the case. So anyway, thank you.
Committee, without objection, will accept it. We have another hunting bill we're probably going to tackle maybe next week, hopefully, so we can probably just do those together.
Super. Thank you.
Thank you, sir.
Thank you, committee.
Are there any other bill introductions?
Thank you, Mr. Chairman and members of the committee. My name is Garrett Henson, and I'm here on behalf of the Attorney General's office to introduce 25 RS 0279, and that is a bill restricting illegal immigrants from receiving public benefits and in-state tuition at Kansas public colleges and universities.
Just as a sorry about that. I was just kind of checking on the germaneness real quick here, but since this deals with the immigrants and that portion of it, without objection, bill's accepted. Oh, I'm sorry. We have one question over here. Representative.
Thank you, Mr. Chairman. And since the in-state tuition bill was part of your recommendation for the new bill, that was put into law in 2004, what's the Attorney General's rationale for bringing that at this date?
What's that? I didn't hear you.
Part of the in-state tuition bill was put into law in 2004. And my question was, why does the Attorney General want to bring that up on this date?
I'm not entirely sure on that, but I can get an answer for you and come back to you.
Any objections? Representative Myers?
Thank you, Mr. Chair. I object to this bill for the same reason the former representative just mentioned with the questions. I don't believe that it belongs in this committee, and this is already a settled matter.
I'll tell you what, instead of me just making a decision on this up and down, I think I'll just take it to a quick committee vote, if that's okay. Everybody on board with that? So we're going to start off with people that would like to accept the bill. Any ayes? Say aye. Aye. Those opposed, say nay. Nay. It was very loud. I want to see a quick show of hands. All the yays, please raise their right hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. And nays? 15 to 6, bill's accepted.
Alrighty, thank you.
Are there any other bill introductions? Representative Miller?
Thank you, Mr. Chairman. I have 25 RS 0243 regarding the expansion of Medicaid. So I've been under the impression since the beginning of this process that this is a federal issue that each state individually has to participate in. So this was the committee that I chose.
Thank you for that, Representative. Not going to do a vote on this one, but I am going to object to the bill because that is out of our scope. That does definitely belong in another committee. Are there any other bill introductions? I have one. This bill is 25 RS 0278, and this one is going to talk about the firefighters, the State Firefighter Memorial. Any questions about that? Seeing none, that bill is going to be accepted. Are there any other bill introductions? Representative Osmond.
Thank you, Mr. Chair. Not a bill introduction, but just a question. My recollection is last year, Fed and State listened to, heard the Medicaid expansion bill. Am I incorrect in my understanding?
This subject's been talked about multiple times throughout this start of this session, and it's very, very clear to me it would not be in Fed and State.
All right, thank you.
All right, seeing done with that, we'll go on to the next chapter. Next chapter, we're going to open up HB 2052 for final action. And Mike, will you run through that with us for us?
Mr. Chairman, members of the committee, this bill deals with firearms and the concealed carry license. The bill clarifies some internal references in Section 1. Section 2 provides that any person who holds a provisional license may, upon reaching age 21, submit a request and get a standard license. There was testimony that the young woman, once she got her provisional license, had to wait beyond her 21st birthday to get a standard license because of the interpretation of the current law. Section 3 deals with the suspension or revocation of a license, requires a surrender actually to the Attorney General. Section 4 is a provision dealing with it's basically a technical amendment. Section 5 is the provision where no person of authority of a building shall require a request personal information of a off-duty law enforcement officer that's entering a building, including that they cannot make them wear any type of identification. That's the bill.
Thank you, Mike. Do we have a motion? Representative Shmoy?
I move that we accept HB 2054. Thank you.
Is there a second? Representative Ward seconds it. Yeah, HB 2052. Yeah, just to be clear. Is there any discussion? Representative Clayton?
Thank you. In something that will probably come as no surprise to committee members, I strongly agree with the first portion of the bill. It makes perfect sense that we make these license provisions. It's ridiculous to make people wait 4 years for something that they legitimately applied for. However, I do have an amendment. We'll go ahead and pass that out.
While they're passing that out, would you like to explain your amendment?
Absolutely. So if you look at page, what is it? Page 8 of the bill, it basically strikes that second provision, that's lines 15 through 43. So if you remember throughout the hearing, and especially members of Fedden State who were here last year, and I know we have a lot of new members, but for those of you that were here last year, that second provision of the bill regarding the concealed carry for law enforcement officers when they were off duty, that was introduced as a separate bill last year, and our esteemed chair at the time chose not to work that bill. I didn't ask him why, but I think it was for a reason. To me, the reason why I'm offering this strike is that I love the first portion of the bill. It makes perfect sense, and this is coming from someone who's not really a gun person, but even I understand how much sense this makes. But this second provision seems a little niche. It seems like it was brought by someone who had a beef with a local establishment. I don't think it makes any more sense for me to bring a change to statute because I'm mad at my grocery store for the way that they ran things than it does for this person. I think that this is a local matter, and I don't think that it is appropriate for us to change state policy, hence my amendment. So that's my explanation. Any questions?
Yeah. Do we have a second? Representative Weiss? Any questions about the amendment? Zero questions. Okay. Oh, Representative Corbett.
Representative Clayton, what seems to be the thing you're concerned about the law enforcement people carrying concealed weapons?
Well, the way that I see it is that, for instance, a lot of the complaints that they brought were, oh my gosh, I'm going to have to wear a bracelet. I'm going to, have to do this and that. And the thing is that I have as of yet to hear from any other law enforcement, in particular in the more populated areas of Johnson County, any of these complaints. It seems like this was based on a one-off incident where one law enforcement officer got mad at one private business in the Wichita area, I believe. And so if we are going to change statute every time a private business exercises what they are allowed to exercise under free enterprise, I just don't feel like we should change statute for that. I feel like it opens up too many doors. I strongly respect law enforcement, but I would say that the majority of most law enforcement officers don't really want this. I think it was that one guy, and I just don't feel comfortable changing statute for that, especially because we heard the bill last year and it wasn't even worked in committee. There had to have been a reason why it wasn't worked.
So if you had an officer who was carrying concealed and he happened to be working undercover, would he have to kind of blow his cover to leave the building and maybe let someone get away?
I just really don't find that hypothetical to be, especially in buildings and events that already have their own security. So you can feel free to vote no on the amendment, but I am running it because I believe in my heart that that is the right thing to do. And I think that this second part of the bill will actually drag down what is a very good and very appropriate base bill that is necessary for the state. So that is my reasoning, and you can vote your district. Thank you, Representative.
Thank you, Representative.
Representative Howell?
Thank you, Chair. Just have some conversation, if that's okay, or comment? Is that appropriate?
I'm sorry, what was the question?
Is it okay to comment at this time or not?
Yeah.
Appropriate to this amendment?
Yeah, absolutely.
Okay. You just had said questions, so I just want to make sure. Okay. So as we heard during the hearing of this bill, we had written testimony from the Fraternal Order of Police, for example, that specifically gave testimony supporting this section of the law or this proposed bill. And for those of us who have been on this committee before, we've had numerous testimony from numerous different organizations supporting this idea of the law or this proposed bill. And so I think that to suggest that it's just one district in one area of the state is not accurate and not representative of what has been presented to us in the past. And so I think that I still stand in support.
In support of what?
Of this bill as it is written.
Not the amendment. Okay. Representative Haskins?
Thank you, Mr. Chair. And I support the amendment, and not so much of a ideological alignment, but more of a and it's of a question of germaneness of why that portion of the bill, how it correlates with the above sections of it. And I would encourage us to withdraw it, have a separate look at this issue, for the simple reason that I don't really fully agree with the business decision. This is my opinion, business decision of capturing all the personal information from the officer. But I think it's a slippery slope if we start regulating what businesses can and can't do when it comes to who comes into their buildings. And I bring her back to our attention, and the precedent for this is last year we had a significant discussion about plastic and not allowing local ordinance to ban the plastic products in stores. And the argument for that is that it infringes upon the business owner's rights. So I encourage us to support this amendment, table the discussion for another time so we can fully vet it and make sure that business owners' rights are not being violated. We did not hear that either in this case.
Any other questions? Representative Reisman?
Thank you, Mr. Chair. I was just wondering, with this amendment, how would this affect federal law enforcement officers that are required to carry a firearm with them no matter where they go?
All the amendment does is strikes the language from that previous bill. So I think that, was that question asked in committee during the hearing of this bill or during the hearing of the previous bill?
I don't believe it was. I don't believe it was, but I'm just questioning about a law enforcement officer that has to carry no matter what, off duty or on duty.
Well, I think that that is up to free enterprise and the private business, but I do think it's interesting that it was not asked at any time during the hearing for this bill or for the hearing for the bill last year, and we did not hear from any federal law enforcement officers in support of it.
Any other questions? Oh, Representative Wagner?
Thank you, Mr. Chairman. I certainly can appreciate the contrary perspective that is moving forward as far as with the presentation of this amendment, but I will say the bill does have cohesion in that both parts of it deal with concealed carry. And so the notion that one is about concealed carry licenses and as far as provisional and permanent, the other is about the application for police officers in a concealed carry as it would be situation. So I don't see it's much of a stretch. Would also remind people, much like the other representative did, that this did come with the favorable testimony, the original bill, from the Kansas Peace Officers Association, from the Association of the Chiefs of Police, and the Kansas Sheriff's Association. That this is actually a, I don't want to say industry-wide, but it's a law enforcement-wide concern. They all came forward to ask us to pass the bill, you know, both parts of it, and I would certainly stand with their professional concerns in this case. Thank you.
Any other questions? Representative Reese.
Thank you, Mr. Chairman. And these two issues are very important. And I have KU Medical Center in my district, and they have their own police force and campus police, along with State Highway Patrol, and all are supposed to be able to carry. What I think a problem may arise is jurisdictional. When somebody enters the hospital with, as a police officer, I think they should be able to identify themselves and probably show an ID if they're from Bel Air, Beloit, some other places that aren't recognizable as far as in Kansas City, Kansas, and in KU Medical Center. And these are both strong topics, and my question would be to staff, can this bill be divided?
Mike?
Yes, if you want to divide it, you can divide it.
Is that a substitute motion?
And then, okay, I'll direct my question to the carrier of the amendment. Representative, your original intent of the amendment is to strike the officers carrying authorized firearms into a specific jurisdiction or location, correct?
That is how the amendment reads. Yes, it is a strike.
Okay, so back to staff. So if her amendment passes, it would strike the first part, or the officers carrying, correct?
What the amendment does is simply strike Section 5 from the bill, because there's no reason to have that section amended if, in fact, you don't want it in the bill. So I've amended the title and the repealer, so the statute that is in question would be out of the bill. In terms of dividing the question, that's really up to the committee. If you, I mean, it kind of, well, anyway, it's up to the committee.
I won't make that motion at this time. I'll leave it up to the committee. Thank you, Mr. Chairman.
Thank you. Any more questions? Okay, seeing none. Well, I personally, on the amendment, kind of personally think it's absolutely silly. I strongly oppose this amendment, but I think it's absolutely nuts that an off-duty officer going to an event has to identify himself to the entire general public at that time. It's just definitely puts them in a position where it's not ideal, for sure. But oh no. Would you like to close on your amendment?
Yes, I would. And I would like to just call the committee's attention to the bill from last year. If you go to historical on your website, pull up 2406, and you can pull up the minutes. Now, it does list that, you know, Chief of Police of Bel Air, Kansas, so that was the same person that provided the testimony. He spoke only about his issue. So this is a one town, one issue thing. Now, granted, it is listed as, you know, the testimony is from several police organizations, but I would posit the theory that if those police organizations really thought that it was that important, they would show up, they would speak to why this was needed statewide. It is my opinion that this is a one person who didn't like the way that one business treated them. And so if we want to go ahead and change statute because one person didn't like it, then that is within the purview of this committee. But I really do want to emphasize that this is no different than me saying that I want my way because I didn't like the way that my grocery store treated me. So if we're going to go ahead and follow this precedent, let's go ahead and do that. I move my amendment. I urge a yes vote, lest we have a slippery slope.
Okay, committee. All those in favor of the amendment, say aye. Aye. Although opposed, say nay. No. Nay appears to have it. Nay do have it. Amendments failed. Back on the bill. Any other questions? Seeing none. Representative Smoy, would you like to close?
I close.
Short and sweet. Back on the bill, take a vote on the bill real quick. All those in favor of the bill, say aye. Aye. All those opposed, nay. The ayes definitely have it. Bill passes. We're going to move on to our hearing now, and our hearing is going to be on HB 2065, and Mike will walk us through this.
Mike Heim with the Revisor of Statutes Office. Mr. Chairman, members of the committee, this bill deals with Article 5, conventions to the Constitution of the United States, and what it does is provides a procedure for the appointment of delegates who would attend a Article 5 convention. Section 2 of the bill is a definition section. Section 3 lists how the delegates would be picked. They're picked by the Speaker of the House, President of the Senate, the majority party, the minority party, and so on. Their term would last. They have to be members of the legislature, by the way. The term would last until the final adjournment of the convention. They could be recalled for various reasons. There's a procedure for filling vacancies. The Secretary of State would certify in writing the identity of the delegates and so on. Section 4 is the requirements of dealing with the delegates and what they have to do. They'd have to affirm an oath to support the Constitution of the United States and the Constitution of the State of Kansas, and to abide and execute any instructions to the delegates adopted by the legislature. Only the chairperson would vote. If he wasn't available, then the vice chairperson would vote. No delegate could consider a vote for an unauthorized amendment. An unauthorized amendment would be considered void. The Revisor of Statutes Office would attend and serve as legal counsel. The Clerk of the House and the Secretary of the Senate would also attend and provide reports and so forth. The delegation would be considered the voice of the legislature. If there is a violation of Section 4 by a delegate, it would constitute grounds for recall of the delegate, and there's a provision that the issue could be referred to the Attorney General, and it could end up with a person being charged with a severity level 6 non-person felony. You heard this, the folks that were on this committee last year heard a similar bill, or identical, I think, but anyway, it passed out of the committee and died on the House floor.
Committee, any questions for Mike? Not seeing in. Thank you, Mike. We're going to start off with proponent testimony, and first up is going to be Michael Ferris on WebEx. Are you with us, Michael?
Yes, I am. Can you hear me?
You may start.
Thank you, Mr. Chairman. My name is Mike Ferris. I'm the co-founder of the Convention of States Project. I'm a constitutional lawyer, have litigated Article 5 cases in federal courts, starting with the issues around the changing of the rules, the ratification of the ERA back in the late 1970s and early 80s. I would like to point out that this bill is not tied to any particular application for a convention of states. There are efforts to get a convention for a balanced budget amendment, for term limits, and for our the one I'm working on, which is was heard in the Senate committee yesterday, which calls for a convention on fiscal restraints, term limits, and reducing the power and jurisdiction of the federal government. And so, but any of those or any other convention that is ever held, whether Kansas is one of the 34 states or not, if 34 states ever agree on a topic and a convention is held, you now have the process in place for how the delegates are chosen. I've looked at and testified in favor of these kind of bills in many states. I will say that your methodology is the most elaborate I've ever seen. And there's a lot of checks and balances here. Bipartisan representation is guaranteed. That's a unique feature to Kansas. The delegation appears to be 11 people, and a majority vote of that delegation would carry Kansas's vote. But so this basically makes sure of a couple things: is that you can't go outside the rule of the call of the convention. If you're called for a particular purpose, you got to stay within that purpose. It affirms the one state, one vote principle, and it affirms the principle that these people are representatives of the legislature and are subject to the instructions and call of the legislature. With that, I'd be glad to answer any questions if the chairman permits that.
Committee, any questions? Representative Sanders?
Thank you, Mr. Chairman. Thank you for your testimony, Mike. So relative to our discussion today, is it appropriate to debate the validity or the desire to have a convention of states, or is it only appropriate to talk about should that occur, the delegate selection process?
Mr. Chairman, may I answer the question? From my perspective, this is about the process only. There are separate legislation pending in both houses concerning the convention itself, and I think that would be the place to debate the desirability. This addresses the issue of even if Kansas doesn't join in the call for a convention of states, if one is called, you're going to have to participate, and this is the methodology for participating.
Committee, any other questions? Not seeing any. Mr. Ferris, I appreciate you being here for us.
Thank you.
And thank you for your testimony.
Yeah.
Next up, we have David Schneider. Welcome to the committee, David.
Good morning, Mr. Chairman, members of the committee. My name is David Schneider, and I lobby for Convention of States. I've been working with Convention of States for roughly 12 years, first as a volunteer, later as an employee, now as a lobbyist. I've traveled the country on their behalf, passing their particular legislation through many states. Again, as Dr. Ferris indicated on WebEx, this isn't our piece of legislation, but we wanted to make sure that we came in support. There is a process in place in the state of Kansas that deals with if, in fact, there is a call for a convention. And if you pay attention to, I believe, Section 1 of this legislation in HB 2065 as proposed, the provisions of Section 1 through 8 and amendments thereto shall apply whenever an Article 5 convention is called. So all the further sections only apply once a convention is called. So to Representative Sanders' point, I don't think we need to argue the fact and merits of if a convention of states is valid or if one should be called. This only deals with the fact is if one is called. And there's a procedure in place for the state of Kansas. We'll put this in perspective. Article 5 is a process in itself, and many states had to deal with a process when the 21st Amendment was proposed by the U.S. Congress to the states for ratification. Many states had no process to deal with ratification of amendments that were to go to conventions in the states. And the states had to quickly scramble to come up with a process to deal with ratification conventions in each one of their states. Now, our wonderful state of Kansas didn't like the 21st Amendment, so we chose not to come up with that procedure. And still today, we have no procedure for dealing with ratification of amendments sent to us by Congress to be ratified by convention, because we didn't like to, we never adopted the 21st Amendment. It still became part of the Constitution because enough states did. So those states all like South Dakota and Nebraska, all passed laws quickly to deal with that measure. All we're asking today is to avoid that type of situation and have some procedure in place. If an event like an Article 5 convention is called, we have a process in place where we can send our delegation. And again, I'll stand for any questions if there are any.
Committee, are there any questions? Representative Reese?
Thank you, Mr. Chairman, and thank you for being here this morning. How many states have already put Article 5 into law in their states? How many states do we have?
Mr. Chairman, Representative Reese, I think your question is how many people or how many states have applied to join a convention of states or an Article 5 convention?
The original bill is to apply for membership for the Convention of States, or is it to be part of the Convention of States?
This bill has nothing to do with an application to apply to Congress for a convention of states.
Getting back to my first question, how many states have already applied?
In general, I believe 49 out of 50 states have applied to become part of a convention of states, but never have we had 34 states agree on why to meet. So we have never had a call for a convention of states adopted by Congress. There's several efforts. I'm a part of one effort that's trying to call a convention of states based on subject matter, which is to limit the size, scope, and jurisdiction of the federal government, term limits on members of Congress and federal officials, and anything that reduce fiscal restraints or put fiscal restraints on the federal government. But there are other efforts out there, such as term limits only, a balanced budget only efforts that have been going on for 50 years, and those efforts are ongoing. And those states, I'm not an expert on it, but I think there's some indication that there are around 30 states on board with a balanced budget. I know we have 19 states on our effort, and hopefully 20 today with South Dakota having a vote on their Senate floor.
Thank you, Mr. Chairman.
Are there any other questions? Representative Wagner?
Thank you, Mr. Chairman. No, thank you, Mr. Snyder. Very, very interesting testimony and very helpful. The 21st Amendment, was that the repeal of prohibition, or what was that?
It was Mr. Chairman, it was the repeal of prohibition. The 18th Amendment was repealed, which Kansas was very instrumental in getting the 18th Amendment, so we decided not to repeal it.
And if I may, and so, of course, Convention of States, I've been here for a number of years, it's been up, it's been voted on, certainly got the majority in the legislature. The question I have is, and I know in the current status, there's whatever, 20-ish states, that have passed the one Convention of States. But of course, I think this is really heads up, this bill, as far as providing for the delegate selection and also some genuine checks and balances, are clearly provided for. My question is, you've been involved in this topic for a long time. How many other states have a delegate selection method already? How common is that?
It's fairly uncommon, actually, but there are several states that have it. When you look at 50 states, I believe somewhere in the neighborhood of 12 or so have this similar laws. Dr. Ferris probably would be better at answering that particular question. If you would want an exact answer, I think he would be more than qualified to answer that one.
Representative Miller?
Thank you, Mr. No? Is it? Okay, sorry, I can't hear. Let's try it again. Thank you very much, Mr. Chairman, and thank you for being here today. It's nice to have some experts on the issue in the room. I have a little bit of a lack of understanding of where it's decided who chooses the delegates. It was actually my understanding that Congress would be the deciders of the delegation process. Where is it in the, I guess, the understanding of the Article 5 suggesting that the states are the ones who choose the delegates?
And Mr. Chair, in Article 5, obviously, when you make application for this convention to happen, it talks about, obviously, on 2/3 of the several states' legislatures, and Congress shall call a convention to propose amendments to this Constitution. So your question is, where in Article 5, I'm sorry, does it?
I guess The short version is, what makes us think that we are the ones who choose the delegates instead of Congress?
At the time of the writing of the Constitution, it was pretty much common knowledge at that point. The states had already met in convention several times, including the convention that gave us our Constitution. At the time of the writing of the convention, they had met probably about 11 or 12 different times in the same manner, where states sent their delegation. There's many parts of the Constitution that aren't spelled out specifically, but it was common knowledge at that point that this was the convention of delegates of the states. And the states continued to meet in convention status, not under Article 5, mind you, and they've never met under Article 5, so that point is taken. But at the time of the writing and many times after the writing of the Constitution, it's always acted in that manner. In fact, the first application for an Article 5 convention called it a convention of states, and it was all about sending delegates to propose a Bill of Rights. And Virginia had made that very first application even before Congress sat. So they were very much wanting that Bill of Rights. So it was very much common knowledge at that point, and still up until recent history, which we've seemed to have lost, that this is the manner that states deal with overreach in the federal government, especially when courts have expanded the federal government's scope and jurisdiction.
Committee, are there any other questions? Not seeing any. Thank you for your testimony. Committee, I'd like to go ahead and take a minute to point out that we do have a couple written proponents on the in the packet, and we're going to move on to neutral. We have no neutrals that are listed to speak or written, and we're going to close that side of it and go right to the opponent side of it, and we're going to start with John Axtell. Welcome to the committee, John.
Thank you, Chairman. I'm John Axtell. I'm from Wichita, Kansas, and I'm the volunteer coordinator for Kansas Campaign for Liberty. Honorable Chair and committee members, I oppose House Bill 2065 for several reasons. I've talked in my written testimony about what I see as the inconvenient aspect of voiding votes or enforcing unauthorized votes. I think it's problematic at least, and unacceptable at worst, because I don't see the convention adopting rules that will allow for the Kansas delegation to vote and then have a wait or a pause while it's arbitrated here in Kansas whether that vote is void or authorized. And then they would proceed based on not knowing what Kansas vote really is. So I think that's problematic. But the most important thing about this bill that I need to address is that the bill does assume that delegates can be constrained. And a recent lawsuit offers clear evidence that this is not true. Now, Convention of States proponents, let me talk about this lawsuit. Convention of States proponents don't like the supermajority requirement. I understand that. But it's in the Kansas Constitution, and it's a requirement for passing their resolution. 2 Kansas legislators have filed lawsuit in a federal court to ask the federal court to allow the Kansas legislature to ignore this requirement in the Kansas Constitution and declare the resolution passed with a simple majority. Now, this lawsuit proves what we've been saying for years, and that is that the process of applying for and holding a convention under Article 5, quote, cannot be constrained by the people of Kansas, end quote. Now, those words are not my words. They're the words of then Attorney General Derek Schmidt in letter 2019-10. This letter arguably argues for the lawsuit, and it is based largely on the 1975 Dyer versus Blair federal court case, which is, the words of the Dyer case are very important. They describe the state constitution as precatory. Now, I had to look that word up. I found out that it meant just a suggestion or a wish and having no authority. They say that the state constitution is precatory for the legislature when the legislature is voting under Article 5. It's just a wish. It's optional. And so they're willing to abuse the Kansas Constitution or the state constitution in federal court. Once again, we're not surprised. The Dyer court said that the legislature can find this Constitution to be precatory because they are participating in a federal process. They're participating in a federal process. They're voting under Article 5, even though they're located right here in Topeka in a building paid for by taxpayers, under oath to support this Constitution, and so on. They're still under Article 5, according to the words of the federal court. And the court said, the Dyer court said that when they are participating in a federal process like this, they are free to, quote, accept or reject, end quote, the supermajority requirement. Now, by saying they can reject it, clearly the plaintiffs in this lawsuit will likely win. But by saying that the legislature may also accept the supermajority requirements, they're saying very clearly they are constitutional. There is no supremacy clause conflict here. The court has told us that there is no great patriotic duty to file this lawsuit. It's simply about Convention of States getting its way and being able to ignore the Kansas Constitution. So federal courts will certainly also say that the delegates, and this is where we come to the main point about this, the delegates are also participating in a federal process. After all, they're going to be in a convention under Article 5. They will be participating in a federal process. Therefore, they will also be free to accept or reject the state constitution and all subordinate things such as bills, such as laws, and this bill if it were to become law. Now, this lawsuit against the Kansas Constitution and the basis for it, the Dyer case, it only proves, once again, what we have been saying for some time, which is that the delegates, just like the legislature, may do absolutely as they please when operating under Article 5. I believe the people of Kansas deserve better, so I urge you to vote against House Bill 2065. I thank you for your consideration of my message. I'll be glad to stand for questions.
Committee, are there questions? Representative Lewis.
Thank you, Mr. Chair. I understand you oppose the selection process in the bill. What's your proposal that we do instead?
This segues into a topic that we were told not to address, which is the idea of Convention of States in general. I think that the fact that the delegates cannot be constrained makes the whole process of holding a Convention of States an unwise proposition.
One more follow-up. So you don't have a suggestion for how we would go about selecting our delegates?
I have a suggestion for what we need to do to restore the Constitution, and it's not to hold a Convention of States. Yes.
Representative McNorton.
So, thank you, Mr. Chair. So, in your testimony, it sounded like you were talking more about the convention rules, not about what we're doing here as far as an appointment and how we're going to appoint people. So could you clarify a little bit? You kept talking about the convention rules and the federal government. The way I read this, we're talking about how we're going to delegate people to go to that convention. So please distinguish your argument, if you would.
The bill, House Bill 2065, has provisions for voiding unauthorized votes. It has provisions for punishing delegates who cast, or delegations who cast unauthorized votes. It has provisions for other ways of enforcing what goes on at the convention from here in Kansas. And the point of what I'm saying is, if this is adjudicated in federal court, as the lawsuit against the Kansas Constitution is being adjudicated, the federal court will say everything that you've written in the delegate bill is a moot point.
So if I could
Representative
follow-
McNorton, go ahead.
Thank you. So you're just saying that this bill would become moot because it's being overridden by the federal?
Exactly.
Okay.
We've
thank-
written the Kansas Constitution. It's being overwritten by the federal court. If you write this bill and the enforcement clauses for the delegates, it will be overwritten or overridden by the federal court too. That's correct.
Go ahead.
So one follow-up, thank you. So that's your opinion that could happen. We don't know what would happen, right? And if we ever have a true call of Article 5 Convention of States.
Well, the Dyer court has made it pretty clear in the choice of words that they used. They did call the state constitutions precatory when working or operating in Article 5. And they said that when operating under Article 5 or participating in a federal process, as they called it, that was true, that the state constitution was precatory. It's only logical to conclude that the delegates will also be operating in a federal process when participating in an Article 5 convention. I don't see how that is my opinion. I see that that is a logical conclusion from what the Dyer court has said, and the only logical conclusion from what the Dyer court has said.
Thank you, Mr. Chair.
Representative Sanders.
Thank you, Mr. Chairman. So, of course, we all understand that it's not necessary for Kansas to sign on for there to be a convention of states. It could happen without us.
It's not necessary for Kansans individually to sign on?
No, the state of Kansas. The Convention of States doesn't need an affirmative vote from the state of Kansas for it to happen. Is that correct?
If there are 34 states without Kansas, I believe that's correct.
So then what this bill simply deals about is something that you seem most concerned about, and that's constraining delegates. Do you believe that this bill, whether in your opinion it's constitutional or not, constrains the delegates of Kansas?
Well, this bill is certainly constitutional, but it's not effective. It won't, in federal court, it won't constrain the delegates.
So if this bill was challenged in federal court, would you argue in favor or in opposition to it?
If this bill was challenged in federal court, it wouldn't matter what my argument would be.
Well, does it matter what your argument is now?
I'm not arguing, I'm presenting.
Okay.
I'm presenting the data, I'm presenting what the federal court has said. And I don't like what the federal court has decided in Dyer. I don't like the idea that the federal court would give permission to violate the state constitution. I don't like that. I think that's a usurpation of state sovereignty and state rights. But I'm only saying that with the lawsuit, we have very clear indication based on the background for the lawsuit, which is the Dyer case, that the same thing will happen in federal court when delegates decide to do what they want to do, as is happening, possibly going to happen in federal court, as the legislature has decided, or two plaintiffs in the legislature have decided they want to violate the Kansas Constitution.
Thank you, Mr. Axtell. Thank you, Mr. Chair.
Are there any additional questions? Not seeing any. Thank you for your testimony today.
Thank you for your consideration of my message.
And I'd also like to point out to the committee that there are 3 opponent written testimonies too in the packet. And we'll close this part of the hearing. That does finish our business today, but I would like to kind of just give the committee a heads up. We're going to, I'm waiting on some bills to be read in, to be officially introduced on the floor and then and be assigned to us. Until they're assigned to us, I can't really schedule a hearing on some of these. So you'll notice on the schedule coming up for next week that we'll probably have some that we are going to schedule a meeting, but the content of that meeting will be published or handed to you at a little bit later date. So be prepared for that, that we are going to work several bills next week, and but I'm waiting on those to be officially read into this committee. Committee, thank you for your time today. I appreciate you guys. And that concludes today. We are adjourned.